will be the truth, the whole truth, and nothing but the truth, Mr. Davis
Yes.
and Ms. Parker.
Yes, ma'am.
You may both lower your hands. And Mr. Nutt, you may proceed.
Well,
Okay.
one moment, please, before Mr. Nutt proceeds. May I just respectfully request some requests real quick? Because last time we were here on May 22nd, I let Mr. Logan speak, and I feel like that y'all kind of railroaded me because I'm not really up to date with the legal jargon and what to say and what not to say to get my point across. So I was just wondering if I could tell y'all something before, like, if I could speak freely. Can I speak freely?
You can speak freely when it's your turn to speak. Yes, ma'am. But right now it's Mr. Nutt's turn to speak.
Yes, ma'am.
Okay. All right. Go ahead, Mr. Nutt.
Okay, Judge. So you may remember this case. This is the one where the state had filed to essentially confirm arrears and modify, with the intent being that we were going to release the arrears on the case because our understanding was that the parties were residing together and stop the support obligation. After we filed that suit, I think Mom had filed a number of additional motions, including a motion to transfer, some claims against basically trying to attack an old order or collaterally attack an old order. I think she's filed numerous documents and claims since the AG's office initiated its suit. And last time we were here, I pointed out to the court that they had not served the grandmother on the case. I think it was the grandmother on the case, which she was involved in the order they're trying to overturn from 2017. So we were kind of stuck. The state is still ready to proceed with confirming the arrears at zero and stopping the support obligation if the parties want to do that. But as far as Mom's claims, the transfer, her attack of the order, everything else she's got pending before the court, I do believe that those require service on that third party, and I don't see that that's been completed.
Okay. And Ms. Parker, you're...
All right, guys, buckle up. We open with immediate tension as the mother pleads for a fair chance to speak. She feels railroaded in the last hearing and insists she's been outmatched by legal jargon. The judge holds firm to courtroom procedure, signaling that authority, not emotion, will rule this battle. You can feel a storm brewing already, and we're just getting started.
It is your turn to speak freely.
Thank you so much, Your Honor. First, I respectfully request referral of this matter to the elected district judge under Texas Family Code 201.015 because these motions involve constitutional and federal issues. Second, I object to this case continuing in front of an associate judge. I do not consent to these proceedings, and I preserve my right to file written objections within 3 days. Third, I object to jurisdiction. I reside in Collin County, not Dallas County, and this case was improperly venued. I also object to the continued enforcement of this case because it was initiated through fraud and misrepresentation by a third party, Lizette Shante Wilson, who had no legal authority. Fourth, the Office of the Attorney General does not represent me, my husband, or my child. They represent only the state of Texas, and I'm not voluntarily participating in their Title 4D services. I have a pending federal lawsuit addressing these same issues, and I want the record clear that I'm not waiving any rights by being present here today. And fifth, the child support portal incorrectly states that LaParis Davis was served on June 13, 2025. He was never served. And at the same time, Lizette Shante Wilson, the person the court previously said needed to be served, is not even listed on today's docket. This highlights that the wrong parties are being brought in while the real fraudster is being shielded. And for all of these reasons, I object to the associate judge proceeding further in this matter, and I request referral to the elected district judge, and I preserve all of my rights and federal claims. And that's all.
Mr. Nutt, your response?
Judge, at this point, I mean, if she wants it, my concern is that we're not moving anywhere because she's got a service issue that has not been resolved since the last hearing. And I think last time I pointed out that I just didn't want the case to end up going to district court and having this.
Now the mother unleashes a long list of legal objections. She challenges jurisdiction, venue, authority, and even claims fraud in how this case began. She argues the wrong people were served, while the real instigator avoided accountability. Every statement lands sharper than the last, raising the stakes higher. The courtroom now faces constitutional claims with a fierce determination behind them.
That being said, I have no objection. If she wants it to go to district court, it makes no difference to me. So if the court is inclined to refer it, then, I will not object to that.
Ms. Parker, we can proceed one or two different ways. Mr. Nutt is prepared to take Mr. Davis's child support to zero. He's prepared to release all of the arrears.
It's already been that way, Your Honor. In that last
Well,
court.
evidently it's not, because Mr. Nutt is saying now that there are arrears on the case. And if there are arrears on the case, until they've been taken, till there's been a $0 judgment, it is still accruing interest. So it's still accumulating. But if you don't want to do it that way, we can refer this to district court. You're still going to have to get the third party served, okay? But if what you want is to refer this to district court, Mr. Nutt has no objection and I have no objection. So just let me know what you want to do.
We would like to refer to a district judge.
Okay, then that's fine. We don't have to talk about it anymore.
But you had respectfully, you had stated the last time, Your Honor, that that's what would needed to happen, because you said that you were unable to rule on any of the motions, and y'all also stated that
you're right, but we still needed to get the third party served. So the same thing is going to happen up there. That's going to happen down here. It's going to sit until that third party is served with all of your documents. And so I was just trying to keep it down here so we could keep a hold on it, keep getting it set, so to make sure that it didn't fall through the cracks. But if you are asking that it be referred, ma'am, we can refer it.
yes,
The state pushes back, warning that the case can't move forward until a third party is properly served. The judge presents the pivotal choice: erase child support debt now or escalate the fight to district court. The mother demands escalation, standing firm on her rights, but the judge cautions her that the delay and complications will follow her no matter the courtroom. Pressure rises and no one is backing down.
Okay. So, Mr. Nutt, will you get me an order referring this? What court is this out of? 303rd? That's Judge Atkins. Can you get me a referral order, sir?
Yes, I will get you a referral order.
Okay, then this case will be referred to district court. All other hearings will be handled in the district court.
Thank you, Judge.
You're welcome. If there's nothing further, thank you all for appearing here today, and you're free to go.
Jacob Guerrero.
And Mr. Guerrero, did you also receive an email with the petition that was filed in your case today?
Yes.
And do you understand you have a right to be personally served with that petition?
Yes.
Are you in agreement to waive personal service and to accept it through your email?
Yes.
And do you understand that because you were served today, you had the right to request a reset for your answer time to pass?
Yes.
Are you in agreement to waive your answer period and proceed with an order today?
Yes.
I'll pass the witness, Judge, and ask that the record reflect that Mr. Guerrero has agreed to waive service.
The record will also reflect.
Thank you, Judge. We're here on an order to establish the parent-child relationship. We have an agreement as to all terms. If I could read those terms and then take testimony.
You may.
Judge, so there's one child before the court. Parties agreed to establish Mr. Guerrero as the legal and biological father of the child, Theodore Winborn. Parties are in agreement that his surname would remain the same. It's Guerrero-Winborn. Parties are in agreement to be appointed as joint managing conservators of the child, with the mother having the exclusive right to determine the residence in Dallas or any contiguous counties. Currently, parties do have a visitation schedule that's working for them. They do understand and agree to the standard visitation schedule attached to the order. The father has medical and dental insurance for the child through his employer. Parties agreed child support would be $724 a month beginning September 1st, 2025. There's no retroactive child support, medical support, or dental support. Court costs would be as billed to Mr. Guerrero, and neither party is requesting any non-disclosures, and that is the extent of the order, Judge.
With the decision made to go to district court, the first case concludes. But suddenly, a new matter begins. Another family is now before the judge. They establish legal paternity and settle custody terms. It's surprisingly cooperative, a calm eye in the storm. Yet beneath the politeness, finances take center stage again, preparing for another turning point.